Hello there. Going through a divorce? Considering one? Sorry to hear that, but here you are. Welcome to Splitsville. You'll find Splitsville to be a pretty unique place, a new world really, with its own rules, its own expectations, and in many ways, its own language. But don't worry, you have a knowledgeable guide along the way. And now, here she is.
Welcome to Splitsville. Listeners, today we are very fortunate to have a guest who has got a very varied experience, a person who's been a colleague of mine for quite a while. We have Todd Owens joining us. Todd has had the privilege of being a lawyer, of course, but also he has been a judge in Mecklenburg County, North Carolina, and he also is a certified mediator, family financial mediator with North Carolina, and serves as an arbitrator for family law cases in North Carolina. So he's really been able to do a lot of work in the area of resolution for conflicts for our families in a lot of different arenas. And we get to talk to him today about some of the differences and his observations about how the three different processes work for the families from a unique perspective of somebody who's done all of it. Todd, if you can give us a little introduction of yourself, that'd be great.
Sure. Thanks, Leigh. I appreciate you having me on your podcast. Hopefully I can say something that's worth sharing. When you were introducing me, you noted my having worked as a judge, arbitrator, mediator. And the interesting thing to me is I've also served in several other roles where I've been in a neutral capacity, and it's very interesting to me how different so many neutral roles can be, how much variation there is within being a neutral figure in divorce work. I became a family court judge back in 2007, I think, and served in that capacity for a few years and found that I really, really gravitated towards family law and being a neutral figure in the family disputes. And so after my time as a judge ended, I went to work with Dozier Miller Law Group, where I still am today. So that's 15, 16 years now. And the vast majority of my practice, I am serving either as a mediator or as an arbitrator. There are times where I have served in the capacity as a special master, a referee, a receiver. There's been quite a variety, but it's been very, very worthwhile and very fulfilling work to help bring about the ultimate resolution for those cases from the neutral standpoint, where you're not buying into one side's allegations, accusations, or positions, and you're really trying to find that ultimate either peace or justice.
I kind of want to start in the beginning then, in the order that you sort of did it. So you were an advocate for clients, you were a lawyer first, and then you find yourself on the bench. And I'm sure you remember, in watching your colleagues and when you still have clients that you represent, that the clients are always just really wanting to know, what's a judge going to think? Or, if the judge hears my story, of course I'm going to win. They're going to see the truth. They're going to see the light. What was the biggest surprise when you got on the bench, having been someone who advocated in front of judges for, quite a while, and then suddenly you are the judge? What was the biggest difference?
I will say, sitting there as a judge and hearing one side's story and knowing that you're going to hear a completely different version or a different interpretation of that story from the other side really was eye-opening to the reality that listening to your client and assuming that your client is telling you the truth and advocating, at 100 miles an hour for everything that your client wants is really kind of a foolish venture, in that your clients are not always telling you the whole story, and that there is a different way of interpreting what took place. And there may be something that is less than what your client is really wanting you to push for, that is what would be reasonable or appropriate for a resolution. So there were a lot of eye-opening moments for me as a judge, but some of those were not in the family law context and were really frightening to me to see just how ill-prepared some folks were for that experience, the experience of the courtroom, whether it was the attorneys themselves or the clients going in with inflated expectations or unrealistic expectations, or, as you said, very, very, very well, going in just absolutely assuming that the judge was going to believe them 100%. And that's something that I have really, really seized on as a mediator in trying to make sure that people understand that what you think is not necessarily what the judge is going to think or what the judge is going to believe. And the folks that leave the courthouse asking their lawyers what happened, why did the judge do this, why did the judge do that, those are the folks who go in expecting the judge to 100% believe their version, their story, their goals. And it's been an interesting experience to watch that unfold for folks who sit there and say, I just want to tell the judge because the judge is going to believe this. I've got proof. And then it turns out that what they thought was proof was not sufficient to move the needle for the judge. And it collapses in on them in ways that they didn't see coming and could have avoided.
Yeah. If you were able to, in your capacity on the bench, of course, you had to be very professional and understanding just your role. So you couldn't necessarily tell the litigants or the attorneys what you wanted to because you might have been giving them more honesty and advice than they were willing to take. But if you could go back and stand outside courtroom doors as people are going through, and before they get through that door, what would you tell them?
That's really a wide-ranging thought process that they should go in understanding that there really is some truth to that, and the idea of and forgive me for not having a better phraseology for it, but the splitting the baby kind of approach of, was it Solomon, wisdom? And yeah, so they really need to understand that there is an extremely good chance that the judge is going to believe some of what they have to say and some of what the other side has to say, and that in the struggle for the judge to figure out what is best for this family or what is justice, what is equitable, that there tends to be a lot of movement towards the middle between the two positions. And if they are absolutely hell-bent on trying to go tooth and nail for every single penny they think that they are entitled to, they're going to leave the courtroom very, very bitter and upset that the process didn't play out the way they expected or the way that they wanted it to. That would be one of the things that I would advise them of. The thing that I tell folks all the time is I've got a little oppositional defiance in me, and I don't like being told how to live, what to do with my stuff. And I assume that most other people like to have that self-autonomy. Or is that the right phrase, or just autonomy, being able to decide things for themselves. And they need to understand that the minute they walk through those doors, they've lost that power to make decisions about child custody, about their finances, about how they're going to divide their assets and responsibility for the debts. They lose that control. And if they want to be able to decide what their future looks like, please sit down on these benches with your attorneys and your ex and talk about what your positions are and see if there's some middle ground you can come up with, because there's a good chance you're going to end up in the middle. Do you really want to go through that fight and that additional hostility and animosity and risk losing your position or not getting what you want? That would be another thing that I would tell them. I would tell them demonizing the other side in front of the judge usually doesn't pay great dividends, because the other side is going to fire back with equal ferocity. You end up both looking like you're just trying to tear each other apart, and it doesn't do much to convince the judge of what's an equitable way of dealing with the various issues.
One thing about family court judges is they have discretion. They have a certain amount of discretion. But as a judge, you're also bound by the law, and you have your hands tied in a lot of ways too. Talk about sort of, the idea where you might see like a really great solution, but you can't do anything about that because it's outside of your power as a judge.
So there are times as a judge where you really are hemmed in by what you have the ability to do. And that is something that I definitely warn people about. But to counter that, you hit the nail on the head. There is the vast majority of decision making that a judge does in family court, it's within their discretion. And I tell people all the time, listen, you may think you know what the right outcome is, but a family court judge has almost unlimited power. They can do whatever they want to do. All they got to do is dot the I's and cross the T's. A very clever, very smart judge can make the numbers add up to the way they want to, even if the judge agrees that the numbers add up exactly the way the litigants say they add up. The judge can say, but here are my reasons why I don't think dividing them the way you say is equitable. So I'm going to put my thumb on the scale and I'm going to tilt it in a way that you didn't see coming, and you're going to be devastated. That's one of the real dangers that I tell people about going into family court is you really are gambling with every last dollar that you accumulated during your marriage. And if you're that confident in your ability to play poker or blackjack or whatever your gambling habit may be, if you're willing to go and risk it all on one hand, sure, go for it. But the house always wins. You're going to get damaged by the process. You're not going to come out getting exactly what you want, and that leaves a lot of people very, very bitter. I will tell you that as a judge, there are those times where I've had to look at people across the courtroom and say, I understand what it is you want, and I understand why you think that that's what you should get. However, here's the facts in front of me, and the law says that unless I'm able to find ABC, I absolutely cannot do D. And I can't find that based on what's been presented to me. And I hate this for you, but have a nice day. And that's a very, very hard thing for a lot of people to be able to do. And I can't say, how easy it is for other judges to do it, but I routinely tell folks that it's not a fun place to be as a judge, to tell someone, I see that you have a need, and I think that you ought to be able to receive what it is you're asking for, but I can't make that happen. And yeah, so forecasting to folks what you think the right answer is. There are times where I think you can ask the attorneys to meet you in the back hall and tell them what it is you're seeing, and say to them, of course, I haven't heard all the evidence and I can't forecast what the end result's going to be, but what I'm seeing is a very significant potential that it's going to land here. And if you guys want to take some time to talk with your clients about that possibility, we'll take a recess. Please go talk with your clients and decide, how you want to proceed. I think it's very, very bad form for a judge to tell attorneys mid-trial what the result's going to be, because that means that they've closed their ears and they're no longer listening to the evidence and the possible arguments. But I think it is worthwhile to be able to forecast to attorneys if you see one of those kind of roadblocks coming up, and see if they want to adjust their strategy.
I'm going to switch gears to arbitration a minute, because it's another decision-making process. It's another way where, for listeners that don't know, in an arbitration, as opposed to going into the courthouse and having a judge assigned to handle your case, and you're going to be in front of that judge unless they're sick or something happens. Some people can choose to do the litigation process in front of an arbitrator, which means you hire someone who's skilled in making the decisions, but they're not an elected official up in the courthouse. They're a private person to make the decision. So as you're an arbitrator, you're still the decision maker. So you're still the judge, just not on the government docket at that point. But explain sort of in that decision-making process, what's different about it, for the litigants from your perspective, is coming in front of you as, the judge within the litigation system in the courthouse, or coming in front of you in your office as the arbitrator?
So arbitration is almost identical to the trial in some aspects, because you are allowing the neutral person to make the ultimate decisions. And there are, however, a lot of pros in that list of pros and cons between arbitration as opposed to going to the courthouse. The pros are, the attorneys can select who the arbitrator is going to be. So they may have a long history with that arbitrator and know their strengths in terms of different, family law issues, and their speed and efficiency at trying cases. With arbitrators, there is, generally speaking, a great deal more availability in terms of scheduling than you have with the courthouse, because the judges have massively overloaded dockets, and finding the time to have a matter heard can be very, very difficult. Whereas with an arbitrator, you may be able to get a case completely tried in very short order, depending on how everybody's calendars line up. So additional benefits are arbitrations done in private. It's in the arbitrator's office or in one of the attorney's offices in the conference room. And you don't have the public spectacle of the courthouse. It can be a lot more informal. And again, there's the time flexibility. Some folks concern themselves with the fact that the parties have to pay for an arbitrator, which is understandable, whereas the judge is being paid paid with tax dollars. They have a salary from the state. But what they don't understand is that the time that it takes to get into court and the motions and discovery and all those trips to the courthouse to finally get a trial date, there's a lot of time that gets spent. And there's a lot of times additional attorney's fees and costs for all that extra litigation, where it tends to be that going to arbitration may be more cost effective than going to court because of the ability to do it expeditiously. So from my perspective as an arbitrator, it really depends on each case, because the agreement to arbitrate, they can have a very, very specific agreement that details that we are going to strictly adhere to the rules of evidence, the rules of procedure, and we're going to be bound by it just as if the arbitration is a private court, private judge. Whereas in other instances, it can be done much more informally. And the arbitration agreement can say that we're going to do a loose approach to the rules of procedure, loosely follow the rules of evidence. We're not going to have a court reporter. We're just going to get in there. We're going to hash it out real fast and let the arbitrator make the decision. So there's a lot more flexibility from an arbitration standpoint than there is from going through the courthouse. For me, as the arbitrator, my decision making is exactly the same as it was as a judge. I'm listening to both sides. I'm weighing the evidence that they give me, their arguments. I'm looking at the case law they present, and I'm going to bluntly make a decision that I think adheres to the law and the facts as I determine them. But of course, the downside is I'm a stranger to that family, just like a judge is. I'm not invested in that family long term, and I'm not part of that future path, which is where the difference between arbitration and mediation, where the parties choose their path as opposed to the arbitrator deciding it. I find a great deal of satisfaction in the arbitration work, knowing that I've helped someone get an end to their litigation much quicker than they would have gotten by going through the courthouse. But I will tell you that I think the vast majority of my significant arbitrations, the parties are both disappointed with the final decision, the same way that they are coming out of the courthouse. They both think they deserved more or that the other side deserved less, and they want to question my decision making. And that's fine. That's their right to do it. But that's, as I have said, the downside to going into a litigation, whether it's arbitration or the courthouse, fully expecting the decider, the jurist, to see it the same way you do and see the right outcome the same way you think it should be.
Well, I think most domestic attorneys prefer to represent their clients well in mediations. Most attorneys are trying to hope that their clients can resolve it in mediation. You have the opportunity to serve as a mediator probably as much as you or more than you do some of the other roles. I know you've been mediating for quite a while. So for people that aren't familiar with it, tell the listeners what you as the mediator love about mediation as opposed to being the decision maker.
Right. So the true value of mediation is that at the end of the day, if there is a settlement, it is really, in truth, something that the litigants have created. I am a facilitator of a conversation. I'm not making decisions for them. I can tell them that if it was arbitration or if we were in court, what I, as the arbitrator or judge, might have done on a particular issue. But I stress to them in mediation that that's just information for them to think about. I'm not making decisions. At the end of the day, mediation is an opportunity for the litigants to both express their goals and concerns, and then we all work together to see if we can build a path forward that addresses each of those goals and concerns in a way that the parties can live with. And I can live with it is, I think, my favorite phrase with mediations, is because it is not you're not declaring victory. It's not a win or lose situation. It is an acknowledgement that you have your argument, but recognizing that the other side has their argument and neither of you are entitled to get your way. Let's see if we can find something in between our two positions that's going to be productive, that we can live with, that's going to be helpful, lets us move forward. For me, mediation is all about planning for the future. What's today going to be? What's tomorrow going to look like? What's a year from now going to look like? Whereas in arbitration and in court, you're really doing the cosmic scoreboard of what happened last year, 6 months ago, 16 years ago, and who got a demerit, who acted badly, who acted well. How does that add up into the great cosmic scoreboard? And then, what's a fair way to divide it? That's win or lose. And so that's where there's a lot of anxiety. And that's why there's a lot of disappointment with going to court or going to arbitration, because you don't end up getting your way. And whereas with mediation, you may not love the result, but if both of you leave saying, yeah, I can live with this, the family has created or found the solution to the issues that they are struggling with. You get solutions in mediation, solutions to problems. All you get is an answer in court or an answer in arbitration, and it's someone else's answer. It's not the parties. They don't own it, and if they're disappointed in it, there's usually not much they can do about it.
Yeah. Now, you get the opportunity the way that mediation is done in most of the counties I've been into, but particularly in Mecklenburg, where we don't put the parties in the same room typically.
That's right.
To do mediation. We allow them to kind of keep the confidentiality of being in a separate room and having open discussions with their attorney and the mediator. But how do you view the difference between going back and forth between the rooms and listening to the parties talk to you about their situation in mediation versus what you witnessed when you're doing arbitrations and you're in the courtroom and people are kind of doing the same thing.
Right.
They're advocating for their position. But, when you're going back and forth, how do you see it as being different from the other two processes?
It's extremely different because as an arbitrator, as a judge, you are getting a very distilled version of their case, of their facts, because of the rules of evidence. A lot of things can't come in. A lot of things are extraneous or irrelevant, and the attorneys know it, and they're going to object, and I'm never going to hear the whole story or what it is that's truly inside the litigant's heart. What it is, or what they're really thinking. Versus in mediation, when we're in those separate rooms, it's wide open. The litigant can share anything they want to say, and it can't come back to hurt them because I, as a mediator, can't be dragged into the courtroom to repeat anything they say to me in mediation, so they can let it all out. And sometimes that means mediations go fairly long because people have a lot of anger, a lot of resentment built up, and they want to just talk and talk and talk about what they've lived through, and that's fine. They don't get that opportunity at the courthouse. They don't get to share the wide open, rambling kind of narrative about their life with their ex who they don't like anymore. But in mediation, they can. And so I think in mediation, people have an opportunity to really be heard about their innermost feelings and fears and thoughts. They have an ability to be heard in mediation, whereas they don't in court or in arbitration. The difference is they can talk and talk forever, but the mediator can't make decisions based on that. So the mediator absorbs that information, and it helps them, when they go into the other room in terms of their interaction with the other side, because the other side has a different story to tell. And a lot of times as a mediator, you end up playing devil's advocate. You end up kind of poking holes in what one side is telling you because you've heard some interesting details from the other side's room. And, a lot of times in mediation, the real juicy stuff comes out and it helps you shape that settlement conversation to say, hey, I'm hearing about all these things in the other room. I'm going to tell you, my feeling is if you go to court, if you end up deciding you want to go to court, those things are going to be said to a judge, and those things may not go over very well. So if that helps you change your thought process on the settlement offers you want to make, hopefully that's going to be helpful. There is a real art, I think, and I'm not saying I'm an artist by any stretch of the imagination, but I think there's a real art in mediation to how you deliver the message, when you deliver certain aspects of the message to try to not just make the point, but convince one side or the other that maybe you want to concede on this thing or concede on that thing and focus your attention a little bit more on something else. That process of playing out that back and forth can be very, very rewarding because it can help folks sort through what it is they're feeling about the other side without it being done openly and with all the hostility and adversarial process of being, again, sitting across from each other in the courtroom or arbitration, and pointing those fingers. People become very, very defensive. Whereas in mediation, it's easier to convey some of that information without the hostility taking over.
People are that are going through this process and they're paying attorneys and they're having to deal with the expenses that are associated with separating. As an attorneys, we have clients that are resistant to going to mediation simply because of the cost. And I've often tried to say it's really a good process. And yes, we can keep sending drafts back and forth with the other attorney. I can keep advocating for the language, but I believe the mediation process to get the final documents together is more cathartic than these attorneys batting drafts back in front of each other.
Yes.
I think you will get more out of it. So you agree as the mediator that the parties seem to be more settled or get more out of the resolution than they do just skipping that process and trying to get the documents done?
I've done them both ways. Of course, we all have. Sending documents back and forth, unless you are able to actually get it resolved, what you end up producing are people who are more and more dug in. They've got their heels dug in even deeper, and they're completely opposed to what the other side wants, and it sets them on the absolute fast track to litigation. So I try, in terms of sending those offers back and forth, to really minimize that. And if it doesn't look like there's a really good chance of that settling quickly, of saying, well, let's not get bogged down in drafts and back and forth. Let's go ahead and get into mediation, because there's a real value to not only the speed of having everybody under the same roof and everybody focused that day and not having to wait for weeks at a time for responses, but also having that neutral person there. That neutral voice a lot of times can really bring some of the pointers home with some of the litigants who aren't really wanting to hear the reality from their own lawyers or from what the other side, the other attorney, the opposing attorney has written in letters. They may be very dismissive of it. And that brings up the issue of client control. Some attorneys are better at making sure that their clients understand the harsh realities of what it is they're facing and what the law looks like. Others, from time to time, will just say, hey, if that's what you want, that's what we'll go fight for. And they don't really get that message across to their parties or their clients as to just how badly the various issues or their goals could turn out for them. So sometimes attorneys who do that kind of approach, they end up setting up the mediator to be the bad guy as the messenger of all the bad things. But that's okay. The messenger is the proverbial messenger. I mean, the mediator is the proverbial messenger who's going to get shot at in both rooms, depending on the information that they're conveying. I think it's much more cathartic. It's much more productive for folks to hear, not just from the mediator, but the mediator's understanding of what the other side is saying. And it can help them understand what it is they're really facing, as opposed to just being isolated with their own attorney and trying to get to a resolution just with their own attorney. It gives them other viewpoints. And that can sometimes be very, very helpful in that decision-making process.
Well, we always come down to the fact that it takes two parties to reach a resolution, but it only takes one to create the conflict and get you in the courtroom. Because if one person doesn't want to resolve it outside of a judge's decision, the other one really can't do that much about it to a point, how they go. But if you could give advice to anybody who's looking at, I'm going to have to go through this process. If there was one thing that you could tell somebody who's I don't have a choice, I'm getting ready to have to go through a separation, or I'm getting ready to have this conflict with a significant other, what would be the one piece of advice you would give them when they're looking at how to do it? What should they keep in mind most as they're thinking about, how do I get this resolved?
All right. So I want to make sure I tracked your question. Someone who's thinking about starting the separation process?
Yes.
Okay.
And, and they want to make sure that they're going to end up with a resolution. What's the best piece of advice you would give them?
It depends. Of course, that's the lawyer's favorite response to every question. It depends. It really does depend on the variables. If we're talking about where we have minor children involved versus just assets and debts. I think the thing that most people really need to hear is that as much as they may be angry at the other side, they need to recognize that they did choose that person to be a partner at one point, whether it was a partner in marriage or a partner in parenthood. They chose that person, and they can't be all bad. They may have really made you mad, but you chose them as a partner at one point. So I would tell them, I need you to keep an open mind about how this process is going to play out. It could be a long road. It could be like a roller coaster ride where there's peaks and valleys and there's good and bad to it. But they need to keep an open mind about what the ultimate resolution is going to look like, because it may be a lot different than what they have come into my door thinking that they're going to get, because they've heard from friends or family about asking for this or for that. And I need them to keep an open mind and understand that nothing is etched in stone. Whenever I hear them say, well, I just want what I'm entitled to, I say, I need you to understand that you're entitled to only one thing. And that's the opportunity to go in the courtroom, stomp your foot, pound your fist on the table, make your argument, and then cross your fingers and hope to God that the judge sees it exactly the same way you do. Because if that doesn't happen, then you're going to end up with something very different than what you think you're entitled to.
I know you and I have shared this before, but, we talk about the F word. Like, we don't want people coming in saying the F word. You just absolutely do not say fair.
That's right. That's right.
It's too subjective. It's not a defined thing. And so, we hear people all the time come in and go, I just want what's fair. And
I tell people all the time, if you feel the urge to say fair, reasonable, or equitable, I want you to hit the brakes and remember that those are subjective thoughts that live within the mind of the beholder. So your idea of fair is probably completely different from the other side. So try not to say it. If you think that the other side is asking for too much or is being mean, okay, say that. But if you say they're not being fair, I'm going to tell you, hold on, that's your perspective, but theirs may be somewhat different. And as part of the mediation process, it's not about getting what's fair for either side. It's about coming up with something that addresses those goals and concerns that each of them can live with. If they're expecting fair, they shouldn't go near the courthouse, not in family court, because they're not going to like the result.
And that's coming from a former judge, current arbitrator, and mediator. So, Todd, we appreciate you joining us. I think there's always a lot of questions about what's the best way to approach, a resolution if you find yourself in this situation. And we appreciate all of your insights.
Well, thank you very much, Leigh. It was a pleasure to join you. I always enjoy working with you.
Well, and I enjoy working with you as well. We've done it a long time, haven't we?
You keep talking about how old I am, and I'm not really liking that part.
Oh, we're just experienced.
Yes, like fine wine.
Experienced, exactly. Well, thanks again.
All right, thank you very much, Leigh.
So there you have it, another neighborhood of Splitsville explored. There's still so much to learn here, so I hope you'll tune in to the next episode. While Splitsville is not a fun place to be, thankfully it is full of helpful people, valuable resources, and sound advice, if you know where to look. See you next time.
The insights and views presented in Welcome to Splitsville are for general information purposes only and should not be taken as legal advice for any individual case or situation. Nor does tuning into this podcast constitute an attorney-client relationship of any kind. If you're ready for compassionate and reliable legal guidance on your journey, contact Leigh Sellers and her team at www.touchstonefamilylaw.com.